right. Zoom loads everybody back into the room at its own pace for reasons we will never be able to explain, but hopefully we can get there. We've pressed the admit button for Miss Reynolds and it just says joining ... and it's sitting there. So I don't think it's anything in her hands, but
I think sometimes when you have to click on the recording requirement, you have to approve recording.
The got it or leave meeting.
Sometimes if people don't click on the got it, they won't join. And sometimes it's a connection issue. So
buttons are overrated. Bring it on. Die.
Oh, there she is.
All right, Miss Reynolds, we just want to make sure we've got you back with video and audio. And
no audio just yet for Miss Reynolds. I'll send her a message.
She's got to tap the screen and then she's got to press the bottom on the left-hand corner.
Here we go. Hi, Judge. I think she's connected now.
All right, Ms. Reynolds, we're going to resume with the respondent's case in just a moment, but as I glanced at my notes, I had a question that I forgot to clarify before we took our break. And you mentioned, you discussed an incident involving power washing and whatnot. I did not get a date. I did not write down a date next to that, even though you may have given me one, but approximately when did that happen?
I didn't have a specific date. It was late summer.
Okay, yeah, and that's a perfectly reasonable window to give at this juncture. So that's all that we look for. Sometimes people feel pressure to go through their phones and say, oh, it was the 15th, not the 17th. That is not time well spent. So
yes.
Late summer just gives me enough of a time frame to understand where it is and the chronology of things. So sir, this would be your portion of the case to present evidence or testimony. Understanding any statements you make can be used against you in other proceedings potentially. If you intend to testify, I'd ask that you raise your right hand for me now. And do you swear that any statements you make to the court today will be the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. What would you like to tell us today in relation to this case?
Well, simply put, Your Honor, I'm being lied about here. I've never put my hands on Becky. I never would put my hands on Becky. I've never put my hands on a woman. I've been in martial arts training since I was 8 years old. I was in the Explorers NYPD police program by the time I was 12. I've been a bail bondsman. I've been a mixed martial arts fighter, and I've been a professional wrestler since the age of 14. I do not have a criminal history of violence against men or women because I know better than to put my hands on people. She was talking about the pressure washing job being in late summer. Well, I remember in late summer, and then she said it was with my right hand I did it. Your Honor, I can show it like this. If you see my hand here, there's knuckles here, but there's no knuckle here. I had an injury that summer, and with this hand here also, on these fingertips, my right hand, the same one she said I grabbed her with, there's straight bone through here. If you listen, this is tapping a normal table with my left hand. This is me tapping with my right. It's straight bone. I have no grip with this hand. I haven't had grip with this hand in close to 10 years. I couldn't have grabbed her and flung her around. What this came down to was money. I was paying all her bills. Miss Reynolds refuses to get a job. Miss Reynolds is in the middle of trying to get disability because she does not want to work. She wants to get disability, but then I had another video that I also had submitted to evidence that I would like to show the court right now, if that would be okay with you guys.
Do you know what it was marked or labeled or titled?
Video 2.
All right, let's see if a member of our team can screen share that.
And while the court's pulling that up, I might object to relevant. I mean, I don't know what's in the video, but if it's strictly about issues about finances, I mean, that's certainly not
Oh, no.
on the petition.
That's the double balance. This goes with the balance issues and her saying that she can fall over very easily, things of that nature. I'm just trying to build a standard to that. She's not.
I'm sorry, Judge. We only have one video, and I think the other exhibit is text messages.
I believe I sent it around the time it may have gotten caught. Is there any way to check?
Yes. Did you get a response saying that we received it, or it was too long or anything?
I'm looking to see right now. No, I did not get a response from it.
Okay, so that means
it was only a video that was, in my estimation, equal in time to the same video as I sent you guys earlier.
Judge, I'm not saying anything, but I will double check.
Thank you for that. Also, in the evidence were photos, which she states also how after that incident, she had to separate herself from me, and she was very worried and fearful for her life. But in there is a text message from January the 3rd, where you could see she's actually being apologetic towards me because I was the one who was victimized that night. I was the one who was assaulted. I didn't yell at Rebecca. I didn't grab her. I didn't throw her against any cabinets. That's not who I am as a person. And in the text message, which is also in evidence right now, it says, I can understand if you're not ready to talk yet. But she was asking for rent money. The fact is, this wasn't the first time Rebecca Reynolds has hit me. She has hit me on 3 separate occasions. And each time it's been under the guise of she had been drinking alcohol to a point of blacking out.
Objection, Your Honor. We're here on the petitioner's petition. Any incidents outside of what was listed here wouldn't be relevant to the question that's before the court today. The respondent, of course, has the opportunity to file his own petition if he feels he needs protection.
Right, but to issue this order against him, I'm required to find that he's been the predominant aggressor in acts of family violence. And so
Understood.
the determination of that requires an examination of the history potentially in either direction. So, sir, you can tell us about these incidents. And as I mentioned earlier, I don't necessarily need hard dates, but what I say is whatever comes into your mind first as the way you would pinpoint it is probably the right answer. So if it's last summer, or if it was early this year, or if it was last week, whatever that is
I have a pretty good reference on the dates. The first time she got drunk and she spit on me while I was driving, my buddy Lorenzo was in the car with me. She was blackout drunk, and then she punched me in the. That was around the winter of last year winter, not this past winter, not this winter that we're currently in, but last year's winter. In the springtime, she wanted us to take mushrooms, and me and her to have a threesome with another one of her friends, Jerry Mize. And when I did not want to interact in the sexual act, she proceeded to get angry when I did not make it okay for her to have sex with another woman. So she punched me in the face and called me a piece of shit. And the last time she hit me would have been on New Year's Eve. On 3 separate occasions, she's hit me. And to be honest with you, Your Honor, I haven't made a thing about it because at the end of the day, I felt like she was going through a tough time still from her motorcycle accident. And maybe these were just anger things that were coming out. It's so much an issue and our worry for her and the danger she is to herself and to me that her mentor, Joe Hamilton Jr., Nick Patrick, reached out to me, and we had spoken to.
Objection to hearsay.
Yeah, you're not able to talk about,
She opened the door because this is why we contacted the psychologist, Your Honor. I'm just setting a standard for what she spoke about earlier about contacting the psychologist.
right, but she didn't. So here's the difference. She talked about changes that were made to her medication or to her treatment, whatever it was, through that person, which is different than introducing out of court statements. So you're talking about a conversation you had with Mr. Patrick, but Mr. Patrick is not here to be questioned about any statements that he made or how he came to know that information or what it means. And so that's different than, acknowledging that a conversation took place is different than the statements themselves.
Okay, understood. I have left her alone ever since New Year's Eve. The only contact she had asked me, as there's in text message form there, for rides to wrestling shows and to training. And I told her that I didn't want to be in the same car as her. One time, finally, my mother made me give her a ride. I know how that sounds, but my mother made me give her a ride to the car. And I asked her to please sit in the back seat of the car so we could have as much distance as we could. And she still proceeded to yell at me in public because I did not want to pay for her extra carton container of soup out of my own money because she wanted to be able to buy cigarettes. I've stayed away. My only contact with her every night up until the order of before the order of protection was when I'd cook dinner for my mother, I would cook dinner for her too. And I would hand her a plate and I wouldn't say anything. I would just hand her the plate and then walk away because I wasn't going to let her starve. She is a sick person. She needs help. She knew we were leaving. She knew I was done paying all her bills. And this was her act to get me out sooner so it would cost me money because she was upset that I wasn't going to be there no more to pay her bills. Because she decided to rely on me for money until she could get her money from disability. Did we ever get the video by any chance?
No,
The second video?
No, we did not receive the second video. Like I said, the only thing we have are the text messages.
Okay, well then I can't show that piece. The other part is this. Like I said, I've stayed away. I know she likes to walk up to the block to go to the bars and party and do all that. She said she's separated from her friends and everything, but she goes out with her friends every night and that's fine. But I've tried to do my own thing. And the problem is that she shows up to events I'm working at that she's not booked at. She's not a part of. A good example would be this past January, I was booked to be the producer and director of a wrestling show in Rome, Georgia. And she proceeded to show up on her own. And she proceeded to stand backstage in the locker room in the middle of a small locker room when she wasn't even an invited guest to be at that building that night. So much so, she was reprimanded by our boss for showing up at this show. And basically, I'm just trying to do my own thing and I'm trying to stay away from her. And I've done a pretty good job with it because I've done everything I could to try and help her. And it's turned around on me into this now. And,
Right.
Trying to tell you these stories about how she's delicate and she loses her balance and all this, and that I grabbed her by the wrist. But you could just go on her social media and you see video of her wrestling 200-pound women running up the turnbuckles like something you see in Crouching Tiger, Hidden Dragon. But she's trying to tell you that I can knock her over. But I never even touched her. I'm not a woman beater. I've never been a woman beater. I have been assaulted in this case. It's embarrassing for me to say that, being 6 foot, 300 pounds. And I know she's 5'3", 120. But the truth is, I'm the one who's been assaulted here.
Well, you've made references to text messages, and we have not.
They were
Kind
the
of.
photo.
Yeah, so I think those came in. Are we able to look at those since he's made reference to them?
PDF, and yeah, in there you'll see the money I've spent over the past months just supporting her, thousands upon thousands of dollars, text messages where she's asking me for money to pay bills in its complete form. Right there is some text messages right there. I'm sorry, I'm trying to read them. I can't see that far. Is there a way for me to? I believe that's, what's the date on that one? What time do you need me to be ready by tomorrow? That's the one I was telling you about after the incident. If this is somebody who was so scared and fearful for her life that she pointed her gun at me, then why is she asking me for a ride to wrestling show she's not booked at? And when she's told there clear as day she's not booked, and she says she figured she wasn't, she's still showing up. That's not me instigating anything. This is her instigating.
So does this jump? Does the communication cease basically between the 6th and the 11th, and then it picks back? Or is this? Is there a separate break here that's not in?
I'm sorry. I'm trying to see what that one is.
So
Did you want me to go to page 2?
The screen on, not yet. So the screen on the left is from January 6th. The screen on the right is January 11th. So
that the one on the right is something about Instagram. That one doesn't matter. I'm sorry about that. It was the one on the left I was trying to send as itself because I had to transfer everything over to PDA. So the January 6th one, as you can see right there at the top, it says, "What time do you need me to be ready by for the show tomorrow?" And I tell her I don't want to put her in an uncomfortable situation giving her a ride to the show. This is a person who was in fear of her life, but she's asking me for rides to shows. You can't have it both ways.
So, and so I can understand the context of what all is going on here. So what is, I know in certain small business operations in all fields, there's people are the Swiss Army knife. They wear many hats. So what is your job or role or title, if there is one that can?
Okay, I am the producer. I am the director. I am I'm the guy who goes between different promotions, getting them to work together to present the Deep South Wrestling brand. So I guess I'm a chief brand officer in that same role. I'm a performer on the shows, although I have been very limited on that role here in the recent months.
So I'm inferring something from these text messages, but I don't know if I'm inferring that correctly or not. So let me just ask, do you have some role the same way a manager would at a retail outlet in shift assignments or work?
Yes and no. It still all has to be cleared by Joseph Hamilton Jr., also known as Nick Patrick.
So you might come up with a slate and then submit it to a higher up for approval, and they might give it a thumbs up or make changes.
Yes.
For example.
And Nick, who made this change, that was on this one.
Okay.
Nick was the one off the card because she said her leg was hurting when she went to training and she couldn't go down to make pinfall counts or anything. And obviously you have to be able to do that in order to perform on shows.
All right. So I think that's all the questions I have for this page. Were there other pages of these messages? I think they all went in as one big attachment. There's messages you wanted to show.
There's the Cash App showing the money, the amounts of thousands of dollars I've paid for her for all this time. You know, I was paying all her bills. I think that text message might have some relevance too. I have to see it. Yeah, that's the one where she's asking me to pay the electric bill, I believe, that I had paid the electric bill for her.
So what was the window of time that you two lived together?
Your Honor, I've been paying her bills since beginning of late spring.
No, but what was the period of time? Like, did you two share an apartment or home of some sort?
Pretty much I was paying my rent and her rent since May. And I was paying her utilities and I was buying her groceries. And
Okay, did she live in a different location prior to May?
she was living in that same house. I was living in a different location, but I was still paying all her bills. I was paying her portion of the bills. Then her roommates moved out. And that's when I moved in with my mother because I got tired of paying my rent and her rent and my utilities and her utilities and my groceries and her groceries. I was paying for everything for everyone, Your Honor.
Okay, and so at the time the petition was filed, you two were living together at the location that we saw in the video earlier.
Yes, Your Honor.
Okay.
And I mean, technically speaking, we had been living together. It's just we either spent the night at her place or at my place every day.
Two places, but always together. Understood. Okay.
Yes,
And so let me look at page 3 of this exhibit, because I think you were talking about that a moment ago.
Yeah, the left-hand side, that's her requesting me to make payments for the utility bills. What's the other one? Yeah, I think that's the one I meant to send her. Was that, hey, I know you're not ready to talk. That's the one. Like I said, Your Honor, that was what I was talking about earlier about January. You know, she was fearful for her life and she ran away, she said, for 5 days. But I'm sorry. Everybody keeps trying to call me. I apologize. We have a show coming up March 31st and everything's going on. Can you guys still hear me? Hello?
Yeah, you're clear.
Okay. You know, just like I was saying, you know, this wasn't done because I actually assaulted her. This is done out of spite because I've been paying her bills all this time and I was done paying the bills and she knew I was moving out and I was taking my mother and she was dependent on it. If we go all the way to page, let's see, that's 1, 2, 3, 4, 5, 6, you'll see where just the other day, March the 3rd, she made a charge on Uber Eats using my mother's debit card for $41.55. That Uber Eats charge was to the address 1380 Glenwood Avenue Southeast, Apartment A. My mother does not live there no more. I don't live there. We moved out before May 1st. And she's still using my mother's debit card to order things on Uber Eats.
All right. Ms. Jordan, do you have questions?
I do, Your Honor. I don't want to go down a line of questioning that's for something that's irrelevant to you. So I just want to maybe gauge first. So we've got something to say about the finances, but if that's not really factoring into the question, then I can skip it.
Yeah, not really.
Got it. Okay. Thank you, Judge. All right, then let me ask a couple clarifying questions then, sir. All right, I think we've established that you were living with the petitioner sort of up until the point that the protective order was filed. Isn't it true that the two of you tried to resolve this between yourselves by going to a counselor and trying to sort of mediate how you were going to extricate yourselves from each other's lives?
Yes, we had agreed to where I would pay $1,000 for my bedroom and 900 for my mother's bedroom, and she would pay the rest of that, and then share the utility cost. Since that's happened, she's never paid $1.
So isn't it true that any contact that she got from you from the point of this incident was about financial issues between the two of you regarding your shared residence or potentially her expenses? However, but primarily financial. Isn't that right?
I wasn't in charge of her finances no more. I was just in charge of taking care of my finances.
But that's what she
Which-
was reaching out to you about. Isn't that right?
I'm sorry.
That's what she was reaching out to you about. Isn't that right?
She attempted to reach out to me on more than one occasion, face to face, about other things, and I told her to please text me if she wanted to speak to me. I did not want to speak to her person to person at all.
Okay.
I wanted to protect myself and have everything in text message.
Okay, but the text messages that you showed, it's primarily about the rent needs to be paid, these expenses need to be paid, that of that nature. Is that right?
Yes.
Thank you. I'll just ask this one other question on this line. Isn't it true that when your mother moved in, you and the petitioner had an arrangement that she was going to help take care of your mother and that you were going to provide the expenses, pay those expenses for the house and the utilities and that sort of thing?
The original agreement was she had to be there for my mother, help her wake up in the morning because she has COPD. So she had to be there for my mother when she woke up, make sure she was breathing. Everything was good with her COPD because COPD attacks happen in the morning. Make her breakfast, make her lunch, and then I would take care of dinner. And then we were supposed to share the cleaning obligations. She did not live up to that end of the agreement. You can't live up to the end of the agreement when you disappear for a day or two at a time whenever you go out on a bender. So
let me just stop you real quick because my question is, part of that agreement was you were going to pay those expenses. So that was
yes.
Okay.
Yes, and I did pay expenses until we broke up and we spoke to the mediator, and it was proven that she could no longer fulfill her obligation.
So up until January 11th, when you talked to that mediator, that was the agreement you were operating under.
Well, she broke that verbal agreement 3 specific times before January 1st. So we had the agreement was off the table, but I still lived up to my end and paid the rent and paid the bills up till January. All of the bills, yes.
All right. Judge, I don't think I have anything further.
All right. Each side has the opportunity to make a brief argument. You may hear that called a summation. It's just a chance to accent certain facts that you think are important or telling, or to state a synthesized version of your case. Since it's the petitioner's case, Ms. Jordan can choose whether she goes first or last. What would you like to do?
Judge, I'll reserve for final close.
All right, sir, you've just given your testimony. Do you wish to make a closing argument or a summation at this time?
Yes, Your Honor.
All right, go ahead.
Look, I'm not a woman beater. I've never been in my life, and I never will be. I don't hit women. Even when I'm paid to do it, I don't do it. Miss Reynolds has very serious mental health issues, drug addiction issues, alcoholism issues, and rage issues. This is just another version of it where she wants to hide from it. Her father's worried about her. Her mentor's worried about her.
Objection.
I do, and I'm worried about her. But I can't do anything else no more. And my mom's worried about her, even though she went as far as to steal from my mother the other night. Becky, I'm sorry that this has all happened.
All right, we're not going to address the parties directly through.
Okay. I'm sorry. Okay, I'm sorry, Miss Reynolds. Is that better, Miss Reynolds?
No,
Can I do it that?
That's you don't talk with each other. It's not okay. even in the I guess supervision of the court, if you want to call it that. But
yeah, okay. The fact that it's gone this far and I've had to deal with this and be this upset really hurts me because I simply put, I have not assaulted this woman. I've been assaulted on numerous occasions by her. I've been used, I've been manipulated, I've been cheated on, I've been physically hit, I've been physically struck. And it's embarrassing to have to talk about this all in public. It's embarrassing for me as a 41-year-old man to admit that I've been abused by a woman. And I just I want this to be over with. Like I've shown, I have the proof is she hit me in the video. I'm not yelling at her. I don't have her cornered. You never see in any of those videos me pushing her. There's no videos or photographs of me hitting her or bruises or anything because they don't exist because I've never done it. None of that exists. But what does exist is people who have seen her spit in my face and hit me, and people who've seen her cheat on me, and people who've seen her use me for my finances and use me for everything that she can. And we're here today, and I'm hurt, man. I'm hurt right now. I don't know. I want this to be over, but I'm not going to be blackmailed. I don't know how much money Becky was trying to ask me for through the lawyer earlier to make this all stop, but I'm not going to be blackmailed into some money that I don't owe. I don't owe her money, and I'm not going to just give her money to make something go away.
Objection, Your Honor.
Yeah, that's not, one, you don't talk about settlement discussions, and two, these aren't the kind of things that get resolved with money. They pretty much get resolved with agreements to leave each other alone. So, all right, Ms. Jordan, what do you have?
Thanks, Your Honor. I was going to make several objections, but I trust the court to siphon out the things that were in the last argument that were, speculation, not proven, not facts that were in evidence at the time. The thing that is before the court, though, are the allegations that were in the petition. So he says that there hasn't ever been any bruising or hits. That actually wasn't, that no hits that were in the allegation. The basis for this is, the unlawful restraint by refusing to let her leave her room. The video that you saw, Your Honor, showed that is exactly what happened. There's a recording of her screaming for him to leave and him not leaving. That is the basis for the order, or that is the underlying basis for the protective order, or one basis for it. She's not alleging that he hit her in that moment. She's alleging that basically her petition is based on the fact that he was in the room, refused to leave, kept her cornered so that she couldn't leave, and that his action, that by the look in his body, like the demeanor in his body and the words he was saying at the time would amount to an assault, though that's not a contact assault. It's words and acts that would lead a reasonable person to fear for your safety. She testified that she is in fact in fear for her safety. You've also heard that about this past incident where there was a grab. Again, it's not a push, or it's not a hit argument. It's that his grab would amount to a battery, in that it is contact that a reasonable person would find offensive or intimidating. And on that basis, we're seeking for the protective order. The financial piece, is not really an issue at the court. There was communication following the incident itself, but as you saw, that was all related to them extricating from each other's lives while they were still very much intertwined, and the petitioner was completely dependent on the respondent for her finances. So no part of that should indicate her degree of fear. It should indicate her degree of desperation for needing for rent to be paid and for expenses that she had relied on him to pay to be paid. So as I said, Your Honor, the question before the court is whether he's committed acts of family violence against her. There's been multiple incidents that the court can rely on to issue that order, and we'd ask that it be granted.
All right. There's certainly there's a lot to unpack here when we have testimony from the parties through a period of time, and I want to kind of level set about a few things. There are a lot of things that can get you a protective order that don't involve putting your hands on someone. What we are tasked with is figuring out how those things played out, and if the answer is that they did, also figuring out whether they constitute an offense that would be an act of family violence, which would involve the respondent being a primary aggressor. And the law, and having competing claims lays out, at least 7 things for an officer to consider, and another 13 that they're supposed to evaluate in the context of a police report that they prepare if there were a report. I know that's not what we're dealing with, but those guidelines provided to law enforcement are the same kinds of things that we look at in this court. This at the time of the incident that the video was shared, there's a shared residence. It can't be in that context a trespass, even if she wanted him to leave. And so do I believe that it rises to the level of a false imprisonment? I think I have to say no. While I understand her state of mind in that context, I don't think there's an affirmative act so much as a passive remaining or resistance on his part. And let me be clear, I certainly don't think in the context of the setting in her room, the disparity between the parties in terms of size and physical capability, do I watch that video and think that she's a predominant aggressor or has committed a crime? No, I don't. But do I look at what was going on and think that that constitutes a simple assault under Georgia law with Miss Reynolds as the victim? And that is the question that I really have to answer. And I don't think I can say yes to that. I don't think that I can say that she was in fear of, there's nothing in the video that shows an attempt to injure. That's one type of assault. The other type of assault is placing someone in reasonable apprehension of immediately receiving a violent injury. And I think that there is enough evidence from the testimony that's been given in the record today by both parties that I can't find that an act of family violence exists. What I'm about to say is editorializing, but I'm going to editorialize. And what I'll say is this. There are little things that you notice in these hearings. And even though my ruling is my ruling, because I think it's what I have to do, there are signs of the type of power and control dynamics here in some of the interactions I've seen that worry me. And I think that I am duty bound in my role as a judge to rule the way that I've ruled today. But what has been made clear, if everyone is being honest today, is that each of you wants to be left alone by the other, and each of you wants to go on your own way peaceably. And what I say to make it as clear as possible in these cases is that I have never said no to a protective order, but I say not yet. And what that means and how this will be reflected in the record is what's called a dismissal without prejudice. Protective orders, issues of family violence are in many, many ways colored by past interactions between the parties. And so the door is never closed to discussing things that have already been discussed if more things happen and they need to be discussed again. This court is here and this court is ready for that should that day come. What I hope is that when I say what I've said, that's heard and that these parties, I don't know if I even want to say coexist, but I know that to some extent you were in the same circles at a minimum, but that each of you can continue to live the life you want to live without interference, and whether that is verbally, professionally, or otherwise. I have no doubt, especially now that Miss Reynolds has Miss Jordan's information should she need her. If there is conduct that should follow from this, it's not often that somebody feels emboldened by the dismissal of a protective order or by one not being granted, but nothing ever prevents the refiling of a protective order if one needs to be filed again with additional information added and then testified to in the record. And so my ruling today is that I am denying this order. I'm wishing the parties the best moving forward separately as best as possible, to the extent that there is an intermediary or someone else who can handle interactions between you two on a professional level. I hope that person can volunteer willingly and capably for the job. We are going to place both of you back in the waiting room, and then you'll be free to log off from there.
Thank you, Judge. Ms. Reynolds, I'm going to send you an email in just a second with a Zoom link so we can sort of rehash what happened. Okay.
Okay.
I think that's it for me, right? I don't. Is there?
Yes, Mr.